Welcome, everybody, to BHBA's Retirement Division Red Flags and Foundational QDRO Basics. I am Ryan Wedeking, co-chair of Beverly Hill Bar Association's Family Law Section. A few announcements before we get started today. We have a happy hour coming up on February 5th at 6 p.m., which is a cross-practice networking night between the family law section, the entertainment law section, and the litigation sections. And that is at Above 60 in Beverly Hills. We hope everyone joins us. This is something that we're trying to do a little bit more of, getting some cross-pollination between the practice groups, and litigation and entertainment law are two very good groups for us to be acquainted with. In addition, we have a number of upcoming MCLE events, including on January 27th, Palimony and Marvin Actions, What Family Law Practitioners Need to Know. On January 28th, International Family Law, Islamic Law in International Family Law Matters. On February 2nd, Everything You Need to Know about California's new joint petition, that's Joint Petition for Dissolution. On February 4th, we'll have the annual Four Corners, the 2025 family law case update. And on March 11th, we have bifurcation issues with Aaron Gray and Judge Luna. So we hope you attend those events as well. So thanks again for joining us today. The Family Law section is sponsored by White, Zuckerman, Warzowski, Luna Hunt, LLP, and SoberLink. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of assistance to you. Learn more at wzwlh.com. SoberLink, as you might know, provides objective, real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases, to help ensure smooth negotiations for a more efficient legal process. Consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interest. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. Now, for today's presentation, I'm delighted to introduce our speakers, Natasha Tang Mendoza and Carrie Holmes. Natasha is a QDRO specialist with more than a decade of experience, having prepared, reviewed, and supervised the drafting of thousands of QDROs across military, federal, public, and private retirement plans. Known for her precision and deep technical expertise, she now serves as Chief Operating Officer and Director of Training for QDROCounsel and is Director of Legal Services for the Center for Access to QDROs. A frequent speaker and educator, Natasha is dedicated to expanding access to retirement benefit division services and supporting individuals navigating divorce and financial hardship. Carrie Holmes is the executive director of the Center for Access to QDROs, where she leads efforts to help low-income family law litigants secure the retirement benefits they are owed. A dedicated advocate for access to justice, she serves on statewide technology and legal service advisory committees and remains deeply involved in pro bono and community organizations. Previously, she held leadership roles at San Diego Volunteer and Lawyer Program and the Harriet Buhai Center for Family Law, building on a career that began in private family law practice. And I will note that she is a past co-chair of the Beverly Hills Bar Family Law Section, so we salute her for her past service. And with that, Natasha and Carrie, I will turn it over to you.
Thank you so much. That was actually amazing. You did a great job. I don't think we have anything left to say about ourselves. So
I'm good.
So you did great. So we'll get started. My name is Natasha Tang, and I first want to get started talking about QDROCounsel. We're a legal services technology company that specializes in the division of retirement benefits in divorce. So we are excited to be here. I love talking about QDROs. My most this is my favorite topic, and I am definitely a QDRO nerd. I enjoy, helping people, and this is, my calling, which is very strange because this is a very, I don't know, unique calling. Doing QDROs is my calling, so I love it, and I'm excited to be here with Carrie. Both of us are very determined to help both, the individuals, but also family law attorneys understand the issues. There's a lot of issues that are unknown to most people. So we're here to help. We love doing this. It's our favorite thing. So we're excited to be here. And QDROCounsel's mission is to change the paradigm of pension division in the United States. So that's a big, that's a big mission, but we do it with technology because, we're in the age of technology. This is where it's at. So excited to be here. Carrie, did you want to say anything else?
Yeah. So at the Center for Access to QDROs, we utilize the QDROCounsel technology, which they donate to the center so that we can use that to help legal aids, self-help centers, and low-income Californians referred to us by those partner organizations. So at the center, we work all over the state of California with legal aids from, way in Northern California down to San Diego. And it's actually super common in cases handled by legal aids for there to be a retirement benefit, a union pension, something related to public employment. Most private employers have some kind of retirement benefit. But those litigants in particular really struggle to effectuate the court's orders and pay for a QDRO. So we are really lucky that we have the opportunity to, help as many people as we do, and work with all of the wonderful legal aids across the state.
Thank you so much, Carrie. Okay, so what is a QDRO? It sounds like a robot, sort of. So a QDRO, it's an acronym for Qualified Domestic Relations Order. And so basically the QDRO is what effectuates what's written in the judgment. So this allows the out spouse to be someone that's paid out by the plan. So Carrie, do you want to tell us the law?
What's ERISA? Yeah. So ERISA is the federal law governing a lot of different things related to retirement benefits, but including division of those retirement benefits. And ERISA specifically covers retirement plans offered by private employers. So if we're talking about public employees or either state, county, or federal or military, that's governed by other either federal law or state law. So ERISA is specifically for private plans. And the thing that makes QDRO work as a family law attorney so crazy making is that every retirement plan, right, gets to make its own rules about what it will and won't accept in a QDRO. So you can't have your here's my QDRO template and I use it in every case. No, you have to have Natasha's genius brain be like, well, this place wants this thing and then this other one. And that's because of a provision in ERISA, in part, for private plans that says that a QDRO can't make a plan do something inconsistent with its procedures. So that's the source of the family law attorney struggle, I feel like, is that ERISA gives the plans a whole huge amount of power. So yeah, that's kind of the general legislative background to working with QDROs.
So how does a QDRO work? Basically, each QDRO, with some small exception, but each QDRO is geared to each retirement plan. There are some plans that allow, so motion picture industry, you can divide both the pension and the basically 401k with one QDRO, but most retirement plans need separate QDROs. And it works as instructions to the plan on how to divide the retirement asset. So whether it's a 401k or a pension, it's basically telling the plan, here, this is how and in what fashion you're going to pay out the alternate payee. And it allows the alternate payee to be someone that's paid out by the plan. And alternate payee also referring to the out spouse. I know I didn't define that, but there's that.
And I should say that that also kind of comes from ERISA, right? So ERISA has these anti-alienation provisions and I think Congress put that in there because we don't want, employers to be able to get into people's retirement funds for whatever reason, right? We don't want someone's 401k funds being used to pay like company expenses if the company gets behind. So Congress specifically set up this really tight control over who can and can't access money in a retirement plan. But that's then created this kind of to borrow an econ phrase, this like negative externality where it's really hard then for the out spouse to access their share unless they, can get a QDRO and get that done. So does every retirement plan need a QDRO to be divided? And the answer is mostly yes. Everyone's favorite lawyer answer, it depends. So for the most part, yes. If we're talking about a 401k, a pension, a 403b, yes, you're going to need a QDRO. There are some very highly compensated executives that may have something called a non-qualified plan, and that's like a whole other kettle of fish. We're not even talking about that today. If you'd like us to come back and talk about non-quals, we would love to. But that's like a whole other thing. And then very technically, you don't need a separate order in order to divide an IRA. And we'll talk about, IRAs in a little bit. But that assumes that the language in your judgment is really clear and specific and is exactly what the bank is going to want, and that your client is comfortable sending their whole judgment with all the custody and support provisions to their bank to have the IRA divided. But in general, the answer is going to be yes. Okay, so we've said a couple of times already that a QDRO effectuates what's in the judgment. Sometimes it's helpful almost to think about a QDRO as like an income withholding order or an earnings assignment order, right? You get your spousal support order and then you have to enforce it. So a QDRO is kind of similar to that, right? You get your judgment or other property division order and then you enforce it with a QDRO. So this is really super common judgment language that we see all the time. And I don't want to like freak anyone out because I've also put language like this in a judgment. And I'm about to tell you about all the many problems that this language can cause and does cause. So don't get too scared. So there are a couple of issues with this language. The first one is, if you can see in there in the middle, it has 3 plans: JP Morgan Chase IRA, Prudential Pension in John's name, Fidelity Investment Retirement in John's name. I'm going to tell you that is not, especially for those last 2, that's not the name of those plans. How many investment retirement accounts do you think Fidelity holds? Thousands. Thousands and thousands and thousands. We don't know what specific plan is being referred to in this judgment. And this causes a problem if someone would like to maybe place a hold on the benefit pending entry of the QDRO. If the plan receives something like this, they're going to say, well, I'm not bound by this. This doesn't name me. And they're going to move on. The other issue is that it doesn't say anything about survivor benefits, which we'll talk about in detail in a minute. We also have no idea based on this if there's any separate property in the IRA or in that Fidelity account, right? And the time to determine and quantify any separate property in a retirement plan is, and I know everyone's going to hate when I say this, but it is not upon entry of judgment when you contact the QDRO preparer. It is while discovery is still open, so that there can be, if there's a dispute about it, it can be resolved as part of the judgment process. The other thing I'm going to mention is that there's no discussion in here of who the QDRO preparer is going to be, or when that QDRO is getting done. So what's the timeline for getting it done? Because I know you all include in your closing letters to clients like, hey, make sure you get the QDRO done. You need to get the QDRO done. They wait. They wait so long. They wait years and years and years, 10 years, 20 years. They wait until they actually are going to retire, and it causes a whole bunch of problems that we'll talk about later. So this, despite being very common, not sufficient.
Okay, so let's talk about survivor benefits. Carrie mentioned survivor benefits. And so while most of the time in the QDRO, if survivor benefits are omitted in the judgment language, most of the time this can be corrected. But there are two really big examples of when it can't, right? So federal and military. So the military pension is called the Armed Forces Retirement System. And so the federal pension is the Federal Employees Retirement System. Usually you'll hear people call it FERS or CSRS. Most CSRS members either converted to FERS or they are no longer living. So most of them are deceased. So that's the older plan, which then converted mostly. So when you're writing a judgment, you want to make sure that survivor benefits, if it's these two pensions, is included with the specific name of the survivor benefit. So for the military, Armed Forces Retirement System, that's the survivor benefit plan. If you don't award this in the judgment, there's something called the first order rule. So your judgment is the first order, and many times it cannot be corrected later on. Also with FERS and CSRS, it's similar. The first order rule also applies, but the name of the survivor benefit is called the Former Spouse Survivor Annuity. So that's the FSSA. So lots of acronyms, and we're sorry, it can be confusing, but this is what it is with QDROs. So I'm going to tell you a little story about Kim and her husband, Joel. And so all of the stories that we tell, obviously we change people's names, but these are all real life stories and they happen all the time. And so this isn't like a one-off horror story. These are real life stories that I see all the time. Carrie sees them. We both see them all the time. And so we like to put that warning out there so that you can protect your clients, because that's the most important thing. We want to help people, right? So Kim and Joel, Kim worked for the post office, right? And her husband was awarded 50% of the community property, right? So after the judgment was entered, then they went to do, the co-op, the QDRO for this plan, and they weren't, and she retired shortly after that. So basically, he couldn't get any survivor benefits because it wasn't awarded in the judgment. So that's a big problem, right? And so essentially, Kim then retired, and that leaves Joel out of that survivor benefit. And then Kim died shortly after that. And this is something that happens a lot, and there is no remedy for that. Once it's done, it's done. Carrie, do you want to expand on that?
Yeah, sure. So I think for a lot of us family law attorneys, we're like, okay, well, the pension payment is the pension payment, whatever. But from the plan's perspective, the pension payment that they pay out while the in-spouse is alive is different than what happens after the in-spouse dies. And I think we just think like, well, that's all pension. I don't know. It's all one big morass. I have no idea. But very technically, from the plan's perspective, those are two different things. So we have to be super careful about those survivor benefits, because if somebody retires and then gets hit by a bus the next day and we've messed up on those survivor benefits, then the out spouse's payments can stop entirely. We get a lot of, often older women calling us in this kind of scenario, and they cry so much when we tell them that there's nothing that can be done about this. And sometimes people think, oh, well, there's Family Code Section 2610 that says that a party's full community property share of a retirement benefit includes survivor benefits. And that's all well and good, but you have to remember, think back to, your Civ Pro trauma from law school, that federal law is going to preempt that. So the federal law about ERISA, the federal law for FERS, that's going to preempt whatever we have in the California Family Code. So we have to be super specific about awarding survivor benefits in judgments.
So we do harp on this a lot, and this is probably the biggest thing that we talk about is survivor benefits. Everything else is also important, right? But survivor, it's all important, but survivor benefits is very important. It's just, if you don't take anything else but this, award survivor benefits, if that's the intent, right? If that's not the intent, then obviously don't do it. But if it's the intent to award survivor benefits to the out spouse, that is very, very important. Okay, so I will get off that pedestal, but I said what I had to say. Okay. Okay, so another important thing for judgment language is identifying all of the retirement plans. So you want to have the specific names, like our previous slide talking about not just saying Fidelity IRA or Fidelity 401k. You want to have the complete name of the plan. So if you have questions about that, we can help you in any of your cases for free to help you identify what retirement plan there is. So if you know the employer name, we can identify it and help you with that, but include that in your judgment language. And also, each retirement plan has specific language by type, right? So for defined contribution plans, major factors to include is the dollar amount or percentage that you want to award that factors in separate property, the division date, the specific date that you want used, even if it's data separation, indicating that date, and then also including whether earnings and losses should be included. So that's another thing that gets missed a lot. And market fluctuations, it's important because as that money grows or loses, right, it changes that asset. So indicating whether that should be included in the alternate payees award, and then loans, factoring any loans. So if there's any existing loans, most of the time it's included as a community property debt. But if it shouldn't be treated that way, you need to indicate that clearly. And then for IRAs, the division can only be as of date of transfer. So whenever it's transferred to the out spouse, you can't indicate a division date like other defined contribution plans. So like a 401k, you can pick a specific date, maybe date of separation, but with an IRA, it has to be date of transfer. And it can only be a dollar amount or a percentage of the total account. So a lot of times it's an issue if there's any premarital or postmarital. So that needs to be factored in.
I love the opportunity to talk about defined benefit plans because I feel like this is something that I didn't really understand how they worked until I got more into the QDRO world. Defined benefit plans are what you think of when you think of a pension plan, and we'll go into some more detail about different types of them. But participation in them is often mandatory, and oftentimes the employee doesn't necessarily contribute to them. So they are the single most omitted asset that we see in judgments is a defined benefit plan. So Natasha mentioned, helping figure out plan names. One of the cool things about the QDROCounsel platform that we use all the time at the center is this enormous database of retirement plans. It's got like millions of retirement plans in there. So I can put in the name of an employer or a union and pop up every retirement plan offered by that union or employer. So even if you have like a really streperous party on the other side and they don't want to tell you things, we can often come up with that list. So for defined benefit plans, that's hugely important. And then the other thing I want to say about defined benefit plans in judgment language is maybe don't just throw in Marriage of Brown. Uh, I know for a lot of us, it's like that's the thing that I know. That's the case. But depending on the type of defined benefit plan you're dealing with, CalPERS in particular, you might be locking your client into something there that you don't fully understand. So this is kind of an encouragement to reach out early and often to your quadro preparer as you're working on the judgment. Okay. Will you go to the next slide, NT? Thank you. Okay. So we hear about joinders a lot, and the question of what plan needs to be joined and which plans don't, it can be very opaque. And I want to encourage everyone to make part of their practice at the beginning of cases placing a hold on retirement benefits. Because we have the ATROs. The ATROs are amazing. They do a lot. Think to yourselves how many of you have had a case where somebody violated the ATROs. All the time. Like it's not possible that you've practiced family law and not had somebody violate the ATROs. And so doing either a notice of adverse interest or joining the plan can help put the plan on notice that someone other than the in-spouse has an interest in those benefits. Because if somebody makes a withdrawal or they take out a huge loan or they take a lump sum buyout of their pension for pennies on the dollar, destroying a ton of value, or they make a retirement election that removes the possibility for survivor benefits, these are all things that can really, really harm the outspouse. So a notice of adverse interest is basically just like a notice of pending action. Like, hey, retirement plan, there's something that there's someone other than the in-spouse who has an interest in these benefits. It's really fast, you know, you don't even file it. It's truly just a notice. The plans that most plans will take an NAI and then place a hold on the retirement benefit. So not let someone retire, not let them take a withdrawal, not let them conduct any shenanigans related to their retirement benefits. The federal and military pensions don't care about your notice of adverse interest. Those are kind of the ones where they'll be like federal preemption later. But most plans will place a hold, usually for at least 18 months, on those retirement benefits in response to a notice of adverse interest. Now, a joinder is a more formal process, right? You've all probably seen the joinder forms. Certain plans do require joinder. Those are mostly California public plans. So we're talking CalPERS, CalSTRS, county plans, city plans. And the motion picture industry plans also require joinder. I think, not to bring up CivPro again, but let me nerd out for like 2 seconds. I think probably joinder is like the proper CivPro thing, because how can you bind a plan with a QDRO if they haven't been joined to the divorce? But it is kind of like a whole procedure that most plans don't require. I will say also plans held by Fidelity, sometimes they aren't interested in notice of adverse interest, but if you join them, then they will place a hold on the retirement benefits. And we want these because it's great that the ATROs are there, but if you have an opposing party that you think is going to do something that they shouldn't do, this is super fast. It's really simple. I think QDROCounsel does them for like $200. And it can prevent a huge amount of harm. And really, I think probably ought to be our standard of care at the beginning of cases, because there may be a business, there may be a former family residence, or many multiples of those. But oftentimes the retirement assets are up there in terms of the most valuable assets in the community estate.
Okay, so let's talk about defined benefit plans. So there are 2 different types, essentially, of defined benefit plans: traditional and cash balance. So a traditional retirement plan or defined benefit plan allows for a monthly benefit over your lifetime. And a cash balance plan can operate similar to a 401k. It has some of the same features, but you can also have the option of annuitizing it, similar to traditional. So it has some benefits of both. And when you're doing the QDRO, a cash balance plan can be divided similar to other defined contribution plans. So a percentage as of a date certain, or a dollar amount as of a date certain, or as of date of transfer. So you can do both. So common division methods. So a lot of traditional defined benefit plans, you have the option, and these are for private plans, you have the option of doing a shared interest for retired or separate interest QDRO, essentially. So basically that allows for the alternate payee or out spouse's share to be separated so that they're not, if the participant dies, their interest isn't affected. So that's a big benefit. A lot of people obviously would choose that because they don't want that. They don't want to be tied to the participant because they don't want their interest to be affected by their retirement election, their life, or death. And there are several options for traditional defined benefit plans at retirement. So someone can choose a single life annuity. And what that means is it's only payable for their life. So if I had a pension and I decided to retire, I would want to take the highest option, and that the most amount payable would be a single life annuity just for my life. If I'm choosing an option payable for someone else's life, like my husband's, then I would have a joint and survivor annuity, but I would be receiving less for my life. Did you want to make any comments on that, Carrie?
No, that's
Okay.
great.
And so with a separate interest QDRO, the alternate payee can commence at earliest retirement age. And so their share is reduced actuarially based on that commencement date.
Okay, so let's talk about some attempts at some judgment language. So the first one is the alternate payee has a community property interest in benefits which are payable or may in the future become payable to or on behalf of the participant by the plan. That interest is defined as an amount equal to 1/2 multiplied by, and I've lost you all immediately. Okay, I just want to acknowledge everybody zoned out. So what I want to say about this first one is that seems okay, right? There's math in it, so it seems QDRO-y. It seems
Right. Yeah,
perfectly acceptable. Natasha, why is this language a trick?
Well, this is a trick because essentially the result is the alternate payee is going to get half of half when the participant dies. And while it looks okay, if you look in paragraph 2, this is basically saying in the same share, right? As set forth in paragraph 1, the alternate payee will get the same amount or the same proportion that they would have got. And when someone dies, their share is reduced by half. So let's say, again, I'm a participant and then I die. My husband, if we're still married, will get half of my pension. We'll get the half that's payable. But in divorce, they get a quarter if the language is like this, right? It's half of half, essentially. I know that that's very confusing. And I feel like you look at it and it's like, oh, that looks fine. I mean, like Carrie said, it looks fine to me, it looks fine to her, but it's not, because it's not allowing for the alternate payee to get the entire share that's payable at the participant's death. So in this case, the participant died 5 years after the QDRO was filed. And by the time they came to us, it was already too late. So the alternate payee was like, I'm supposed to get the amount that was payable during his life. And unfortunately, no, unfortunately, no, that's not what they were supposed to get, because that's not what the QDRO says. Right. And so there's a lot of tears to be had. And it happens a lot where customers call us and they're crying. They're like, this isn't fair. And I feel so bad and I want to help them, but at that point, there's nothing I can do. There's nothing I can do. And I feel empathetic, but it's just once someone dies and the quadro was already done, you can't take it back. There's no takesy backsies. You can't go back. Sad. It's the very sad part of this. Carrie, you want to expand on that? Any horror stories for you personally?
I mean, I think that the survivor benefits in particular work such a hardship, especially if you're doing a lot of gray divorce and you're maybe representing the out spouse. Ashlyn, we are totally getting there. Excellent question. We are getting to good survivor benefit language. But we want to make sure that you can identify what's good and what's bad. So the survivor benefits work such a hardship when they aren't handled appropriately, and it's this kind of like lurking, scary issue that can get people in trouble.
Okay.
So the other question that I get a lot is, well, the plan has a model QDRO, so that's fine, right? But I don't need to hire a QDRO expert. My client is a pill, and so I don't want to deal. I just want to use the model QDRO, and that's going to be fine, right? And sometimes we get into issues like this. So this says specifically, and this is from model language that was really in a plans QDRO, that if the in-spouse dies, their share doesn't go to the outspouse, and vice versa. If the outspouse dies, their share doesn't go to the in-spouse. It goes back to the plan. So the retirement plan gets the rest of the community property if someone dies. So Natasha, why is this a problem?
So with this language, so if the participant dies before or after benefits are assigned to the alternate payee, then the alternate payee's share ceases. And so unfortunately, this is their language, but you don't have to use this. You don't have to use this. And because, like Carrie was talking about, each plan operates in its own world and has its own rules, you can challenge them. And we always do. So we try to challenge their language. And that being said, sometimes I would say about 5% you can't, but it's worth the shot, right? It's worth a shot to try to challenge them to protect the parties. Because in the end, the plan wins with this language. The plan will win, and there's nothing you can do, but you might as well try before the QDRO is filed to basically say, hey, I want to make sure that the parties are protected, because the plan's looking out for themselves. It's like any large corporation. They're trying to protect their interests, just like you're trying to protect your client's interests. So that being said, there's one more horror story of language.
And then we get to the good stuff.
Yeah. Okay, so if you see this paragraph right here, if the alternate payee predeceases the participant prior to the commencement of his benefits, alternate payee's portion of participant's benefits shall be forfeited. Forfeited. That is a terrible word. I hate that. Forfeited. So basically, in this case, specifically, the alternate payee could have commenced. So there's an earliest retirement age. And in this case specifically, the alternate payee died after earliest retirement age. So they could have commenced, but they didn't. They had the QDRO, it was filed, it's on record with the plan, but they didn't make that option. So then when the alternate payee died, the plan got that windfall. So the benefits ceased and all of that became payable to the plan. So that's the worst, obviously, worst case scenario. And then the participant saying, hey, I worked hard for this. I worked hard for my pension. I was fine to have my ex have a portion of that pension if they were living, but now that they died, now the plan gets it? That just seems unfair, but unfortunately, this is again the model language from the plan, and you can challenge it because we challenge it all the time, and we don't, unless we're forced to put something like this, we don't use it. Can you see this?
Mhm.
Yes, okay.
Okay, so this is much better language. That's in our quadros for our default quadros for the most part. So remember how I said that from the plan's perspective, the benefit payable during the in-spouse's life is different than the benefit payable after death, right? And part of that means that very technically, we want the outspouse, even if the parties are divorced, to be treated as the participant's surviving spouse in order to receive a share of a survivor benefit. So this says in the event the in-spouse dies before the outspouse and they haven't started their benefits, then the outspouse receives the marital portion of what's called the qualified pre-retirement survivor annuity, which is the survivor benefit before someone dies. And then also says that the death of the in-spouse after the outspouse commences their benefits is not going to have any effect on the outspouse. So Natasha, why is this language better and why do we prefer it?
We prefer this because it protects everyone. It protects both the participant and the alternate payee. Awarding 100% of the QPSA, or the qualified pre-retirement survivor annuity, basically protects the alternate payee's interest if the participant dies. And obviously, if the alternate payee dies first, then that share's reverting back to the participant and doesn't cease, like in the previous example, or doesn't revert to the plan. So all of this is better for everyone. And obviously some plans don't accept language like this, like public plans, they have their own. But for the most part, they also have protective language that we can use.
Okay, so let's talk about defined contribution plans. These are your 401ks, 403bs, profit sharing plans, the thrift savings plan, ESOPs, employee stock ownership plans, 457s. These are all defined contribution plans. And the important features of them to remember is that they're not money in a bank account, right? This is money that is invested in the market. So it's going to experience earnings and losses. So sometimes we see cases where maybe someone has a premarital interest in their 401k. And as of the date of marriage, they had $10,000 in there. So sometimes we get judgments that say the in-spouse's premarital interest is $10,000. And that really bungles it for the in-spouse because that $10,000 was invested for the entirety of the marriage. And the earnings and losses on that premarital investment are, sourced from a premarital separate property source. So the earnings and losses on that $10,000 are also separate property. So don't just be looking at a statement as of the date of marriage and saying that's the premarital interest because that value went up and down. And if it was a long-term marriage, maybe it went up a lot. So you can really take a lot of value from the in-spouse in that kind of formulation. For the most part, these are heavily employee funded. Sometimes employers will also contribute. They usually show up on a pay stub. So it's, assuming someone's completing their I&E appropriately, you should be able to locate most of these. Obtaining account statements, if we need to do a tracing or something like that Natasha's going to cover in a second, sometimes isn't possible, right? And I think I've certainly had this issue where a bank was like, well, we don't have those records going back that far, or that was when the plan was with a different investment provider and we don't have any of the previous investment provider's records. And that seems insane to me because what do you mean new investment provider accepted millions of dollars in retirement assets without any records from the prior record keeper? And I'm here to tell you that they absolutely do. So if the plan is transferred from one investment provider to another one, the new investment provider probably doesn't have any of the old investment provider's records. So it genuinely may not be possible, especially if we're trying to establish a premarital interest that started, when they got married and they got married in 1993. Like those records just don't exist unless your client is an engineer and they saved everything. But that's the only exception in my experience is if you've got an engineer.
Okay, so let's cover the three major types of calculations for defined contribution plans. And with a tracing calculation, this looks at the entirety of the account. So it looks at all the quarterly account statements, contributions, withdrawals, loans, earnings and losses, dividends and interest. It looks at everything. And this is the most accurate calculation. Again, like Carrie was mentioning, you would need all of the statements or a majority of the statements for that period. Again, participants started contributing in 1980 and date of marriage was like 1985. It's unlikely that you can get the statements for that entire period. But it tracks the actual account activity, so it is the most accurate and preferred. And also you can allocate the treatment of loans. So let's say the loans that happened during the marriage should not be treated as community debt. So in this type of calculation, you can basically control that. You can calculate it so that the participant is responsible for the loans. That's a benefit of this calculation. So the next most accurate, I would say, is the estimated rate of return. So this takes a blend of stock and bond allocation based on the S&P 500. So we will allocate a surrogate rate of return to apply to the premarital value. So we'll need both the stock and bond allocation. So let's say 70% stock and 30% bond. We use that allocation to prepare this calculation. And it uses an implied rate of return, not the actual rate of return, like a tracing. So it's not as accurate, but sometimes this is the best option people have if they have a starting balance, like the date of marriage balance and the date of separation balance. So the time rule formula, we know about this, is a defined benefit plans, but it can also be used for defined contribution plans, but it's not as accurate. So you don't need any statements. You just need to know the date the participant started contributing, the date that they stopped contributing, and it treats everything the same. So it treats it as if it's time, but like we know, when you're first in your career, you're likely contributing less to a 401k than later on in your career. But in this type of calculation, you can't factor that in. So this is the least desirable calculation.
Okay, so this is in your materials. I'm going to cover this very briefly, kind of differences between defined contribution and defined benefit plans. It does matter which one is at issue in your case. It's not just all retirement. The one thing I really want to highlight for defined benefit plans, which again are your pension plans and cash balance plans, but especially the pension plans. Even if a pension plan went bankrupt or was terminated or the employer went out of business, most private defined benefit plans are federally insured. So there's a federal organization, a federal department called the Pension Benefit Guarantee Corporation, PBGC. And PBGC guarantees a portion of the benefit. So it's even if someone says, oh, that company went out of business, that plan was terminated, there may still be benefits. They're just managed and held by PBGC. And you can still, do a QDRO and all of PBGC will manage that. So it's likely not the full benefit, but there may still be money there. And so you don't have to just accept, oh, this plan went out of business and it's it's gone. There may still be something due to that federal insurance with PBGC.
Okay, so let's talk about individual retirement accounts and different IRA types. So some common types are traditional IRAs, SEP IRAs, Roth IRAs. It is important to know whether it's a Roth IRA, just because if you're trying to do an offset, Roth is post-tax, traditional is pre-tax. So that is an important factor. So the QDRO, quote unquote, for an IRA would be called a 408 order. So the division of an IRA is governed by the Internal Revenue Code. So just like private plans are governed by ERISA, the Internal Revenue Code, the IRC, governs the division of IRAs. So most of the time, you will not need a separate order as long as your judgment is clear. So it has to include the name of the custodian or bank that holds the money, the award, and also the last 4 or 5 of the account number, just to make sure that it's referring to the correct account. So if your judgment does not include that, then you'll likely need a 408 order. Or if, like Carrie mentioned, the parties don't want to send their whole entire judgment with the division of all the property, which they would have to send if they didn't want to do a 408 order. And there are different award issues. So the division of an IRA can only occur as of data transfer. So if it says 50% of the entire account, and there is no premarital or postmarital contributions, then there's no issue. You just divide it 50%, it's fine, as a data transfer. A lot of times, if there's withdrawals or contributions post-separation, that's where you'll need some sort of calculation and then potentially a 408 order. Problem with defective transfers is that this could cause tax ramifications for both the in-spouse and the out-spouse. So it's important to make sure that the division's handled properly.
Okay. I'm really excited to talk about this. This is my favorite thing that we do at the center. And it's something that I feel like I genuinely did not know about until I got very, very into QDROs, because I'm into cool stuff like that. So we can use a QDRO to collect child support and spousal support. And that's very exciting to me. So what we can we collect on a monthly basis, or can we just collect like a lump sum of arrears? Depends on the type of plan that's at issue. So, right, I said that it does matter whether it's a defined benefit or a defined contribution plan. So we have to know that, and we have to, have some other pieces of information. But I think this is a really underutilized tool, especially if someone has, a 401k plan with a chunk of change and they're playing games with support, and we need to collect some, significant support arrears. We can use a QDRO to do that. Now, there are things to think about in terms of taxability and pros and cons and types of plans, but know that this is an option if you're in a scenario where your support payor is presenting a lot of challenges, or if you represent the support payor and they're like, listen, I got into a bunch of arrearages, I want to clear it up, what can I do? If they have a retirement benefit, that might provide a mechanism by which they can get caught up and resolve any kind of issues that are coming up with respect to that arrearage. We see QDROs for support fairly often from Child Support Services Department lawyers. They seem to kind of have more of a handle on this. I will say there is technically a judicial counsel form called a QDRO for support. Would not recommend. I love the energy behind it. But it's just very general, and we've talked, about how the challenging thing about QDROs is that every plan gets to make their own rules. Let me tell you, they really want to make their own rules about QDROs for support. So I've seen a lot of those judicial counsel form ones get rejected. But that is totally something we can do, and it's really powerful and awesome. And then there's also something called a Qualified Medical Child Support Order, QMESCO. Why would anyone find this field confusing? There's only a million acronyms and they all start with Q. All start with the word qualified. So a Qualified Medical Child Support Order if you have an order that a support payor is supposed to maintain health insurance coverage for the children, with the children as dependents, but they're kicking the kids off and there's all these different issues, a QMESCO goes directly to the health insurance plan and says there is a court order that these children are to be maintained as dependents. And so it prevents the employee spouse from making any changes, kicking the kids off. It also can help the out spouse get in contact with the plan and be able to kind of make some decisions and submit things. So it can be very, very, very powerful. And it's, something that I genuinely didn't know about until a few years ago. So keep that in mind too. Okay. So the I really want to encourage everyone, you're going to hate this too, to get the quadros done like concurrently with the judgment or immediately after judgment, and maybe stay in the case to ensure that the quadro gets done. Just because if there's any issues with the language in the judgment, we can often resolve those in the quadro, but if the parties wait a really long time to get the quadro done, which let me tell you, they all do, um, bad things can happen, and here are some of them. So the first is that somebody might take a loan out against their defined contribution plan. Not all like 401k plans allow loans, but many do. And when you take out a loan, that might mean there isn't enough money left in the account to satisfy the outspouse's award. So it can cause a whole bunch of problems.
If the participant dies before the quadro is done, post-death quadros are very difficult. Not only are they difficult to do, they're difficult to get filed. So even though it was awarded in the judgment, some plans don't accept post-death quadros. So again, death is a big issue, obviously, but also in the realm of quadros. Carrie, you want to tell us about retirement?
Yeah, okay. So when somebody retires, especially from a defined benefit plan like a pension plan, they're going to make elections about how they want to take their benefit. And broadly, they can do a lot of different things, but in general, they can either take the maximum amount for their lifetime, leaving nothing left for a survivor after they die, or they can take a little bit less during their lifetime and leave something left for a survivor. And we have had a ton of cases, and they're the worst, where the judgment says that the outspouse is awarded a community property share, whatever, whatever, but then the in-spouse retires and the plan lets them retire. And they make that election so that there's no survivor benefit. That election is not modifiable because the plan will have already conducted its like crazy actuarial calculation about how much it's going to pay the parties. So it's not going to let the person then, make a change to that election. And that presents this like really complex thing. We have it in a case at the center right now where husband retired. He was allowed to retire because the plan wasn't named correctly in the judgment, and he made an election that there's no survivor benefit. So if he gets hit by a bus tomorrow, his former wife, who was married to him for 35 years, her pension payments are going to stop. And we're asked to kind of value her loss, which is almost impossible, right? Maybe he dies tomorrow, maybe he dies after her. It's like totally impossible, but he clearly has destroyed some value that really matters, because if something bad does happen, then she's out of luck. So if anybody's like, I'm going to retire, we want to get a joinder or a notice of adverse interest done ASAP, because we don't want to let someone retire, because in the quadro, there may be a requirement about the type of election that they make so that the outspouse's survivor benefits are maintained.
So I'm just going to briefly finish the rest just because we are running out of time and we tend to talk a lot, and we're sorry. So in terms of the plan transferring, so record keepers change periodically. And as Carrie mentioned in a previous slide, they don't transfer with them. The records don't go with them. And because of that, sometimes it's not you're not able to calculate, the award due to the record keeper change. The participant could move, and then, or the alternate payee could move, anyone could move, and you have problems with cooperation. Signing the QDRO, getting information for the QDRO, those types of things. Or the participant could withdraw all the funds, transfer it to another IRA, and it's hard to track that, right? And so these are issues that we see every day. There's someone that comes with one of these issues. So that's why don't wait to do the QDRO. Do not wait. That's another important takeaway from this. We're going to skip the next 2 slides. So sorry about that. We ran out of time. Talked too much. So if you need help, please contact us. We have a program where we offer free plan-specific judgment language to attorneys to help you in your cases. We will help you discover what retirement plan it is. So I know that there was another question in the chat about how, what resource. So you can contact us. I'll help you in your cases. We find what retirement plan it is based on the employer, or if you have a pay stub or you have the FL 150s or 160s and you want us to look at those, we'll do that, figure out what plan it is. We give you support through the QDRO process. We do NAIs, and all of these are services that we offer for free to attorneys. So if you're part of our program, we can assist you. And we also can discuss, tips for structuring both equalizations and offsets, and also spousal support. Sometimes people want to do something different and use the retirement assets as something to pay out for support. So if you have questions about that, please contact me. Put my contact information here. And did we have any other questions?
I think I've answered most of
Okay.
them. In the little answered tab, I also put Natasha's email in response to a bunch of the questions. So sorry, NT.
Please write to me.
But she does want your emails.
I do.
So
I love them. I appreciate them.
Give her an opportunity to talk to someone about the QDRO issues. She would love it. Yeah, I think that those are all of our questions, and we are only 2 minutes over.
Miracles. Thank you, everyone.